4 years into a 10-year deferred probation sentence, Arthur Stewart was given a chance to stay out of prison, but the court says he ignored one crucial requirement for almost the entire 4-year period. Then a new allegation brought everything back into the courtroom, with the state asking for his probation to be revoked and the judge warning that he could face prison time. The question became, would the judge give him another chance or finally make him pay the price?
Number 2, the state of Texas versus Arthur Stewart. That's you?
Yes, sir.
You're here with Mr. West, your attorney. And the state's attorney, there is a motion to revoke unadjudicated probation that was filed on April 17th of this year. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir, please.
Raise your right hand. Do you solemnly swear or affirm any statement that you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? So
Yes, sir.
lower your hand. In summary, this motion alleges that on January 5th, 2022, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for theft of property, a third-degree felony. Is that true?
Yes, sir.
And it looks like dirt box of a value of $30,000 or more, but less than $150,000.
Yes, sir.
Allegation 1 states you committed the offense of obstruction of justice on or about September 3rd, 2025 in East Baton Rouge Parish, Louisiana, which violates condition 1 of your probation order. Condition 1 states commit no offense against the laws of this state or any other state or the United States. Is that allegation true and correct?
No, sir.
It's not? Okay. Okay. Why was it alleged?
The charge was dismissed on Monday in East Baton Rouge, Judge.
What do you want to do? Just because it's dismissed doesn't mean that you
I
can't
don't
go
have
forward
the
with it.
ability to bring
don't have
people
any?
here for that, Judge.
Number 2 states you failed to report to the Jefferson County Probation Office by mailing in reports or online for the months of February through December of 2022, January through December 2023, January through December 2024, January through December 2025, and January through March of 2026, as directed by this court. I don't believe in my 20 years I've ever seen such a gap of failure for such a long time. So this was the original document. So this is all condition 4. Report as directed by your probation officer and obey all rules and regulations of the Jefferson County Community Supervision Probation Office. Is that allegation true or untrue?
So can you repeat that again?
Sir?
Can you repeat that? Just basically saying, what did you check in by mail or online with Jefferson County for those periods of time? Yes, sir. I know, Miss No, of course, they recall like that.
The states you failed to report to the Jefferson County Probation Office by mail or online for the period of time from February 2022 through March of 2026, which would be 1, 2, 3,
It's the entirety of his probation.
4 years of not reporting by mail or online, which all probationers do when I allow courtesy supervision at another county. I could have said, you're not going to leave this, you have to stay here and you're going to have to report, but you live another county in Louisiana, and I accommodated the request at that time that another
I'm gonna ask you.
with parish or county be the primary location that you would report directly if they would accommodate us. And I guess they did. And you still, though, are connected to us because you committed the crime here. So we still require you to make a form of reporting every month. And for 4 years, you were AWOL on this, as far as I'm concerned. But from probation, when he started failing to do it, when did we, who says this thing was fun? How did it last 4 years without us reeling him in?
Your Honor, I have emails, multiple letters. I have called several times. His voicemail's not set up. He can't leave a message. I've even spoken to his mother in 2022 and sent the information to her on how to report online and mail in report forms. We've mailed mail-in report forms to the address. He was reporting to his officer in Louisiana. And I even spoke to her and asked that she remind the defendant he's supposed to be reporting to us. And
By mail or online?
Online, yes, sir.
4 years and, okay. What's the feedback from them on his direct reporting?
Their progress reports, it took a while to do a progress report as well. Anything through originate contact takes quite a while.
Yeah.
It appears that he was reporting this directive to them.
Yeah. Okay, why weren't you reporting to us?
I never received no calls. The first call I got from him was when I was up on my warrant. After that, I asked to come have a warrant. I came myself some.
What you said?
When the first call I received that I received from her was when she notified me about my warrant. This when I came to myself in.
Here, I'm going to show you what is a document in this court that was filed January 19th of 2022, which was 2 weeks after this court placed you on probation. And those highlighted, what are this? Read the 2 highlighted parts.
It said report to the Jefferson County CD
Probation Office.
By mailing in the report forms or as otherwise instructed.
Okay, is that clear to you?
Yes, sir.
Okay, and and is that your signature at the bottom?
Yes, sir.
You made a deal, a contract with us that you didn't follow through with. And this was signed 4 years ago. Don't even say that you didn't know, because you signed on the deal. Man. Your probation officer, Ms. Martinez did too. Well, failure is not an option with me. You can't say that you didn't know any better because you signed on the contract. What should we do for this?
Yeah, I almost sound like a broken record here. Really just say the same thing as before. But this is a situation where his violations are all administrative. I mean, there's not a new offense or anything like that. That's the good thing.
We have administrative conditions because they're
Oh,
important.
I know,
John.
I'm not saying they're not important, but I'm just saying that it's not a situation where we have a new crime or something like that. This is a situation where there's a breakdown of him doing what he was supposed to do. And it's clear that he signed the document. Now, just because he signed the document doesn't mean he paid attention to it. We're supposed to pay attention to everything we sign. You and I know that. Most people in this room know that, but a lot of people don't. They just sign stuff and move on. And I'm not going to defend that. That's stupid, but it happens. We know that. I think
There's a good reason why they're held accountable because it would be too darn easy for everybody to say,
I understand.
I didn't know what I signed. And it would be worthless to say, sign a document here, you're signing. It's important, make sure you understand it because probation office goes over with when the defendant.
But it's a question, I think
not like he didn't know.
No, but
He knew and he's held accountable for it.
And I think he should be held accountable for that. But I'm saying that he did report in person in East Baton Rouge, and from the reports we got, was doing pretty good. There was no violations or issues. Otherwise, we would have noted there. They would follow that as well. And I think that's one of the reasons why there was no revocation filed earlier until this new offense, the alleged offense, popped up and then brought up. I think a situation as long as he was reporting.
I think it's the fires that we have to put out.
It's minor compared to the blazing stuff that she's dealing with every day. I mean, I know
blazing fires are most.
Yeah. And until there was a major fire, which a new offense would be, now ultimately that offense was dismissed, and so it's not pending anymore. But this brought this to light. But I think the fact that he was reporting in person and doing well, then he should get some kind of, I won't say credit for that, but some acknowledgement for that. And then he should be punished for this, but continue on probation in some form because it's not a situation where he wasn't checking in at all. We get a lot of people that just don't check in and they just go paywall. We see that all the time where they're not checking in anybody.
They didn't check in with us.
Well, he was checking in with his probation officer. In his mind, he was checking in with probation and doing what he was supposed to do.
But I'm losing all contact with him.
I understand.
Okay.
But this is different than somebody who just doesn't check into anybody and is not supervised at all. He was still being supervised.
I know, but you're saying, well, I'm a thief, but I didn't steal but $10. These other thieves that are 1,000 go after them more. But it's still a crime.
Well, Your Honor, in that scenario, the state legislature even acknowledges that a $10 theft is a Class C misdemeanor and
but it's still a crime.
There are crimes, and that's what I'm saying. Him not checking in is definitely a violation.
All right.
There's no issue, but it's in my mind, it's a minor violation because he was checking in. He wasn't supervised.
Okay. All right. I opened the door for one, I opened the door for everybody.
Well, I think
you know what? Hold on.
If other ones fit them, they should walk that door.
From here on out, no one is going. You open the doors. Nobody starts doing the reporting by mail or online, and they can always say when it comes to the head. I want Arthur Stewart's rule. I want the Arthur Stewart rule, please. That even though it's in there, I signed. I made a promise. It's not important, and I shouldn't be held accountable. Well, that's not going to work.
I think he's being. I'm not saying he should not be held accountable, but this is a situation often we have that he's on deferred probation. One of the options we have, and we've used many times, it just used about 20 minutes ago, is that you can revoke him and put him on regular probation.
Let me ask you.
And then have him checking in person.
First things first, Arthur, on allegation 2, failing to report to the probation office here, Jefferson County, by mail or online on all of those months that we went through with you from 2022 through for 4 straight years. Is that allegation true and correct as it is alleged?
Yes, sir.
Are you pleading true to that violation voluntarily and because it is true as it is alleged here? That's yes or no.
Yes, sir.
And do you understand that voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation. Here, your deferred or unadjudicated probation could be revoked. You can now be found guilty and sentenced to this third-degree felony of theft, which is no less than 2 no more than 10 years confinement in prison. Knowing all of that, do you insist on pleading true to this violation number 2 of this motion to revoke unadjudicated probation? All right, I find you were pleading true voluntarily, knowingly, intelligently, and because it is true. What shall we do? Go ahead.
Listen, Your Honor, I would recommend to revoke him and place him on regular probation since there's also some arrears. And I'm not sure, looking at the motion to revoke here, there was one time it was restitution amount of $4,752.50. And then they've alleged
Now, how much has been paid,
that's what I don't know.
if any?
I know.
Have you
Once-
paid any restitution, sir?
Yes,
About how much, do you know?
no,
She does.
Once he was arrested, his mother came in June, on June the 8th, and paid $1,772. June 9th, paid $377. So far the restitution has been credited $1,125. And there's a balance of $3,627 of restitution.
All right, let's stay safe. Or you working somewhere?
Yes, sir.
What do you do?
I work at Amazon. I do pick at Amazon.
Is it a full-time job?
Yes, sir.
How much do you make an hour?
I'm making $19, $20.
$4 grand. Go ahead. You're gonna pay this restitution back.
Yes, sir.
Okay.
I treat him as an absconder. This is, the key word here is courtesy. Whenever we have individuals that come from Louisiana, I'm referring to the underlying charge. This defendant, along with his co-defendant, got a U-Haul, came across from Louisiana. The Louisiana plates were still on the U-Haul. They then went to Cowboy Power Sports, and they were caught in the act of stealing these dirt bikes. There's no connection between them and the offense that they occurred. I brought that up at the time of sentencing whenever the agreement was that he get the deferred probation. He talked then about wanting to get courtesy supervision. I remember, Your Honor, giving him the instructions that we were talking about here. He went over there and he basically thumbed his nose at the court and the citizens of Jefferson County by choosing to do only what he wanted to do. He was reporting to the folks over there and handling, quote unquote, handling his business there. I prefer my supervision officers here and how they handle Jefferson County and how they do. And it speaks volumes to the fact of how they tried to work with this man over the last 4 years to resolve an administrative issue. But for him to stand here today and say he didn't understand it, that he was doing everything he was supposed to, that we basically had to put the paperwork in front of him for him to realize that what he was doing was wrong. I wish I had individuals that I could bring from East Baton Rouge about what had to be abandoned. I cannot do that, but I do want him held responsible. It's too far of a distance, Judge, to bring people about the charge for the obstruction of justice here. On its face alone, the offense here occurs after curfew hours. He's involved with someone who he's actually in possession of another defendant's cell phone involved in a shooting and a murder that occurs over there. And he's caught in the act of deleting those messages. When the officers were trying to continue to interview him, he gave excuse after excuse as to why he wouldn't get there. One of which was that he was coming over here for a birthday party. And ultimately, I don't know what led them to choose to dismiss the charge Monday, but they did. If they were here local, I would bring those folks here. We have a different proof standard, and I know how sensitive you are about any crimes that occur on your watch. The logistics are impossible for me to do that. And all that starts with the fact that we put him on courtesy supervision, him a chance to prove his own conduct. And by his own conduct over the last 4 years, he doesn't want to follow your rules. I want his probation revoked. And in my opinion, he ought to be sent to prison.
Anything else?
Just reiterate, I think it should be, we should put him on regular probation, and if there's an issue with him reporting, take away the courtesy supervision. They can come over here and report. That is alone as a nice punishment. Hopefully having to drive.
Sure.
So that alone is a good punishment, having to drive over here once a month. And take off work and all that.
From probation.
Sure. Yes, sir.
I'm sorry. Go ahead. Awesome.
That's when they signed the, then.
All right. Yeah, maybe the rest of the detention. All in the same, in the same event. as
Same
out of
event.
business. Okay.
Yes, sir.
Then he's just 10 years deferred. This restitution, this was Cowboy
Power sports.
Power Sports here,
Yes, sir.
and they still owe he still owes how much?
But that.
Mr. Hand has a good point in all of this. I feel that you don't come over here, make a mess, and then not fix the mess. So what I'm going to do in spite about this, it's definitely Mr. Hand's idea is certainly a sharp thought. Here's what I'm going to do. And the following findings, I'm going to find that you have pleaded to voluntarily, you did not believe what the says. You and this after discussions with your attorney. This voluntarily, knowingly, no plea proof is sufficient to find this allegation number 2, failing to report to the probation office by mail when clearly knew the discussion. By the contents of the evidence or greater, I find that violation to be proven free. And this motion to revoke unadjudicated probation shall be granted. And earlier in this case, when question on the third unadjudicated probation, pleaded guilty voluntarily, and never was confident to do so and understood and appreciated the consequences of pleading guilty. There was sufficient evidence according to the guilty plea from states that Ziegler admitted to find him guilty beyond the reach of that. I'm now finding beyond the reach of that burden without that you now that follows you around the rest of the and come on over you and make a noise. It's not face problems. So that, oh, the 8 message in Louisiana. On the people here, we got our own province, and we be able to have it. I say welcome, welcome. We love people like this. Don't make a mess into the problem. I find you guilty of not a reasonable doubt, I mean, hereby sentence, find of the municipality of the region of the Texas Department of Justice is overcome 10 years. I will be suspended and placed on regular probation or period of time, which is the difference on the amount of time you have that they can do this. I'm sorry, 7 years. So,
Generally, on the 22 is when we placed on probation.
it's 6.5 years.
It's closer to that. Yes, sir.
Okay, 6.5. Whatever the difference is.
Right.
From the time he was placed on probation to now. And there will be terms and conditions of probation with a similar and to what you have been ordered to do. You still owe restitution, which that needs to be paid as soon as possible, but you're not getting out of here without paying a price. I'm ordering you to serve. I can order you to serve up to 6 months in the county jail. You've been credited with 72 days. You're going to be ordered to serve. That would be 108 days in the county jail, so that you have credited 180 days. You knew better. You ignored the order of this court, but you're going to pay our victims back what you've done. I say, welcome to Jefferson County, but don't come and make a mess in this town, in this county, and harm our people. Now you're convicted, and I expect this restitution to be paid within 12 months after your release. What else from probation, or
I'll just
you go over the
make
terms?
it, yeah,
with him?
sir, he can come to my office.
Thank you.
and release, and I'll go over.
All right,
Thank you, Judge.
that is.
The judge ultimately revoked Stewart's deferred probation, sentenced him on the original felony, and ordered him to serve 108 days in county jail, on top of his existing credit, while demanding that the remaining restitution be paid. His 4 years of missed reporting had finally caught up with him. Do you think the judge got it right, or should Stewart have received another chance? Let us know in the comments. And if you want to see more real courtroom moments, tough judicial decisions, and cases where one mistake can change everything, make sure to subscribe to the channel and turn on notifications so you don't miss the next case.